trusted upon by the Constitution, other laws, and the respective standing orders. Again, my lords, that phase that where the court is supposed to deal with this issue, it is our submissions that this is the stage that this honorable court must ensure, because it is the court, that all aspects and proceedings are dealt with in a manner that we all had, and I'm happy for the time that the court has agreed to allocate us, so that the court with sober minds can be able to decide, have the laws of our countries been upheld or not. My lord, there are clear guidelines that have been set out by our constitutions for purposes of doing that. And my lord, because we are here because of an applications for conservatory orders, under Article 159 of the Constitutions, this court has an express duty that in exercising the delegated judicial power of the people of Kenya, it is required, the certain guidelines have been given by the Constitution under Article 159, that is besides other provisions of the Constitutions. And one of the most important one is that, that the court will do substantive justice. Substantive justice is an important issue, and it has specific meaning through the very many decisions that have been rendered over time by the courts of this country. And the clear meaning in plain English, because it is important we understood in plain English. In plain English, it means a very simple things. That, for example, my lords, if we have a case over a goat, Mr. X and Mr. Y have a case over a goat, this goat should remain alive and so that at the end of the decision, the court can decide whether it belongs to Mr. X or Mr. Y. That is a very simple meaning of substantive justice. So that, my lord, substantive justice, therefore, conservatory orders, is a mechanism that our laws preserves the goat. Our laws preserves the subject matter of the case. The subject matter of the case, my lord, is the questions of vacancy in the office of the president. Going by the Senate, the deputy president was impeached. On account of the orders that have been given, that office is yet to be filled. So that, my lord, the question, therefore, is easy to define and can be defined this way. That, as we wait for the hearing and determinations of this case, it cannot be settled at the interim level that the Honorable Kindiki will now be the Deputy President of Kenya, so that as we argue the petitions, there is already the impeachment process has been concluded to the disadvantage of the other people, of the other person who is seeking the same office. So that, my lord, is a simple issue that is very easy to define. So that, my lord, we shall be arguing that when we come to that particular issue, why on earth, because you have before you, because if a conservatory order is the legal mechanism, the legal device that is established by the constitutions to preserve the substratum of the matter, and for this court to do substantive justice, how on earth does the respondents expect that substantive justice will be possible if the trophy that is being tussled over, that is being contested over, is handed over to them? My lord, all systems of justice would be offended to be told that it is possible at halftime for one team to be declared to be the winner before the matches is concluded. Why can't we wait for all these issues to be concluded? It is a simple meaning of what substantive justice is all about. And the courts, the duties of the court to ensure that the ring is held even for all the parties, so that we do not argue over an academic matter, which would be the worst issues that can happen. My lord, there is the case of the Gatirao Peter Munya. I'm coming to the applications for conservatory order. The principles are very clear. I just need to go on them as quickly as I'm able to. Under Gatirao Munya and other decisions, we have a big authorities, many authorities. The issues were set out very, very clearly. And there are 3 tests. The first test is on the prima facie case. My Lord, my learned colleagues have set out the various many legal issues that are there. That from the standpoint of the applications that we are arguing before you, there are 5 issues for purposes of the prima facie case to comply with the Gatirao Munya case. The first one, my Lord, is public participation. I don't need to go into that. It's a substantive issue in the majority of that issue. My Lord, the second issue is what we call the legality of the standing orders of the Senate. My Lord, in the petition filed in Kerugoya as 015, the petitioners, amongst other things, are saying that although the Constitution provided for clear timelines on how, for example, the business is going to be conducted, and specifically said that this investigative committee is the only committee that can be able to discharge that constitutional function, the Senate established standing orders under which the plenary of the Senate can also resolve that issue. The Constitution of Kenya does not provide for a mechanism on how the Senate can discharge that function. But it is very clear on how that investigating committee is supposed to conduct its business and how the right to hearing is to be given after a finding has been made that there is a case worth responding to. My Lord, I submit that's a big issue on the standing orders that were used to pass the vote of impeachment. The second issue that has been sought in that case is the issue of interpretation and application of those laws on impeachment, 44, all those laws, 48, 144, 144, 149, all those have been raised. My Lord, as you clearly knows, this is a first impeachment for purposes of those laws. And therefore, if a question of interpretation has been raised specifically before you, it underscores the necessity to ensure that on merits, this court actually determines and interprets the law, so that the next time we have probably to do it against the president or against Kindiki, if he gets there, the law would be clear and we shall not be going through all these things. So a serious issue has been raised by that petition. The other serious issues that have been raised is, of course, the fairness of the Senate proceedings. I will not go into that because already the lawyers for the deputy presidents have raised that issue. And the fifth important issue is the issues of nominations of the Honorable Kindiki. That issues of the nominations, my learned colleagues will say more about that. But as we wait for their turn to come, the only 2 issues that I need to say at this early stage is to point out the fact that under the constitutions, I believe Article 137 of the constitutions, any person occupying the office of the deputy president or the office of the president must be qualified in accordance with the constitutions of Kenya. Under the impeachment articles of the constitutions, these issues of the constitutions on the qualifications are not set out. So that because they are not set out, it is an assumption that when reading the constitution holistically, this court will go to those other specific provisions of the constitutions where the issues of qualifications are set out. My lords, those issues of qualifications are many. One, and the body under the constitution, my learned colleague Mr. Ndego will say more about it, is that the IEBC confirms whether any person has those qualifications or not. I don't think that is a contested issue. I believe it is also not a contested issue that at the time that the President of Kenya appears to have received some letter from IEBC confirming that the Honorable Kindiki is duly qualified to hold the positions of Deputy President, courtesy of Article 149 of the Constitution, we did not have IEBC. Of course, various arguments can be taken by the parties that are before you. Those arguments cannot be concluded